Okay, good morning, everybody. My name is Jonathan Teal, and welcome to this legal update webinar for 2021 provided through Legislation Update Service. So just a brief overview of what I'm going to cover. So initially, I will be covering an introduction to how Brexit impacts on EHS legislation. I'm then going to look at some of the key changes to health and safety laws specifically, both the Brexit-related changes and then some non-Brexit-related changes. And I will then look at some other health and safety law on the horizon. I'm then going to hand over to my colleague Esther Morrissey. She will cover changes to environment law as a result of Brexit, and then other non-Brexit related environmental changes. And then she will also look at environmental law on the horizon. And then she will finish with a very brief discussion about some of the massive COVID regulation that we've had over the last 12 months. So I'm going to start first with Brexit. Before I do so, just a couple of words about myself. So I'm one of the consultants with the compliance people. So I travel all over the country doing EHS audits. I've been doing health and safety for just under 20 years, and I've been doing environment audits more recently as well. So if you bring us in to do an audit for you, it may be me that comes to your site. I've also been heavily involved in writing much of the content on Legislation Update Service, and in particular, some of the Brexit-related changes. So I'm going to start with the general Brexit implications for EHS law. So Brexit is most likely to affect your site if you're either making or importing chemicals in a quantity exceeding 1 tonne per chemical per annum. It's also likely to impact you if you're placing or making CE marked goods or PI marked goods on the market, or if you're moving certain products such as animal or plant related products over the borders. So by border there, I mean the border of Great Britain and Northern Ireland. Particularly if you're moving goods between Great Britain and Northern Ireland, that's also going to impact you. And also if you have any obligations under emissions trading scheme to carbon count. Now, there are fortunately no Brexit-related changes to general duties to manage site safety, to keep your employees safe, plan your work activities safely, to manage your environmental emissions or control pollution. There are no changes to environmental permitting through Brexit, no changes to your duties to manage waste, and there are no general duties no changes to your general duties in relation to energy usage, with the exception of the carbon counting, which I mentioned before. So then how does Brexit primarily impact on EHS law? So we have to look at the European Union Withdrawal Act 2018. Now this act did a lot of things, but from our perspective, the most important thing that it did was in effect, it copied and pasted all enforceable EU regulations direct into UK law. So prior to the beginning of this year, all of those EU regulations, so that was things like, for example, REACH, or CLP, or the F-gases regulation, all of those regulations are directly enforceable in all EU member states, so therefore they were directly enforceable in the UK. Now, in order to avoid a sudden dramatic change in legal obligations for businesses in the UK, the 2018 Act therefore in effect copied and pasted all of those EU regulations straight into UK law. So what that means is, for example, on LUS, what we've done is we've duplicated all of those EU regulations. So you'll still have the original EU regulation, which looks like that. So you'll see the title of the law, and you'll also note underneath it, it's got the 3 flags for the jurisdictions. So it's got Northern Ireland, the Republic of Ireland, and also the EU flag to represent all of the other EU member states, because that's where that EU regulation is applicable. But what you now have as well is this new GB retained regulation, which looks like this. So it's got exactly the same name, except at the beginning, it now says GB retained. And you'll see also at the bottom, you have the England, Scotland and Wales flags to represent the fact that regulation is applicable in those jurisdictions. So that means that if you're a business based in Great Britain, you now comply with the GB retained version rather than the EU version. You may well have old compliance comments against the EU regulation, please don't feel the need to try to transfer any of those comments. Those comments should continue to remain against the EU version, because when they went in there, it was the EU version of the regulation that you were duty bound to follow. Obviously, going forward, if you do any further audits from the beginning of this year, if you're based in Great Britain, you now want to put your compliance comments against the GB retained version. On the other hand, if you're a business in Northern Ireland, you continue to comply with the original EU regulation. So why is it then that Northern Ireland is treated differently? So, and we have to go back to the European Union Withdrawal Act 2018 and the European Union Withdrawal Agreement Act 2020. So those two acts, when they were passed, they anticipated that Great Britain and Northern Ireland would be treated as one, and they would have the same rules outside of the EU single market. But of course, as we all know, that's not what then happened following the political negotiations. So we then got the withdrawal agreement and the Northern Ireland Protocol, and they changed everything in relation to Northern Ireland. So what they do is they now provide that Northern Ireland remains inside, in effect, inside the EU single market and continues to follow EU regulations. Now that is why you'll hear me talking about the EU regulations being copied into UK law, but those retained regulations were then further revised to make them apply only in GB. So that's why we talk about a GB retained regulation, which is an EU regulation that was copied into UK law. What that also means is that there are now some quite complicated arrangements for goods moving between Great Britain and Northern Ireland. And the rules are different depending on which way the goods are moving, and we'll cover some of that as we go through some more of the slides. Now, does that mean that the GB retained regulations are the same textually as the original EU regulations? Well, the answer to that is no. Now, obviously, if you simply copy and paste your EU regulation and create a GB retained one, then it would be word for word the same. The problem with that, of course, is that it would then be full of references to EU bodies. It would give power to EU bodies. It would have various other EU references. So what the UK government then did was it made over 100,000 amendments to those GB retained regulations to make those retained regulations work within Great Britain. And just to put that in perspective, that's more than 3 times the total annual amount of change in UK law that you would get in any ordinary year. So what do those amendments do? So they do things like, originally, they amended the scope of the GB retained regulations, restricting them to the UK, but they were then subsequently further revised in order to restrict them purely to Great Britain. And then there were various other amendments that were made in order to reflect the Northern Ireland Protocol. So they transfer bodies from EU bodies, they transfer powers from EU bodies to UK bodies. So for example, powers that were held by the Commission are transferred to the Secretary of State or the HSE or whoever. They create UK equivalent arrangements. So for example, harmonised standards, notified bodies and CE marking under EU rules become designated standards approved bodies and UKCA marking under the new rules. Remove requirements that the EU regulations provide for cooperation between member states, and they provide various transitional arrangements for compliance. So for example, even though all of those GB retained regulations came into effect on the 1st of January this year, a lot of the obligations in them don't come into force until a later date because they're giving businesses time to get into compliance. Now, just a word before I move on then about the entries in LUS. So the way that we have done that is we have initially duplicated all of the EU regulations to create the GB retained ones. So on the 1st of January this year, the GB retained versions were word for word identical to the EU versions. What we then did was we made sure that in the update section of all of those entries, we put in all of the relevant amendments that I've just been talking about. And what we've been doing since the beginning of January, well, in fact, since last year, is amending the text in the GB retained versions to make them aligned with all of the amendments that I've just been talking about. So what we've done is we've prioritized the key regulations, so things like REACH, for example. So they are now fully amended to reflect all of these amendments, but you will still find at this point there are some GB retained regulations where we haven't yet been able to amend the text. We will amend all of them. But what I would urge you to do is, if you're looking at any of the GB retained regulations on LUS, it's really important that you look at the update section as well as the summary and duties section in order to make sure that you pick up all of these amendments. Okay, so I'm now going to move on to some of the key changes to actual health and safety law as a result of this. So I'm starting with REACH, and we tend to get quite a lot of inquiries about REACH. So I spend a little bit more time on REACH than some of the other regulations. So the REACH regulation is obviously copied into UK law. So you have the original EU version and you have a new UK version. Now, just a word of warning here. If you go onto the HSE website, you will see that the HSE talk about UK REACH. However, UK REACH does only apply in Great Britain. I'm not sure why they've done this, because for other regulations like CLP and the biocidal products regulation, they talk about GB CLP and GB biocides, but they haven't done that for REACH. But I can assure you that UK REACH only applies in Great Britain. It does not apply in Northern Ireland. So you would be complying with you should comply with UK REACH if you're based in Great Britain, and you should comply with EU REACH if you're based in Northern Ireland, or of course anywhere else in the EU. So who does REACH apply to? So it applies to manufacturers, importers and distributors who are making or importing any type of chemical, hazardous or non-hazardous, in a quantity exceeding 1 tonne per chemical per annum. Now, there are many exemptions. So if you're dealing with food, medicines, cosmetics, many low-risk minerals, chemicals involved in simply production and research, polymers, radioactive materials, or waste, all of those are exempt from REACH. But assuming you're not, so assuming you're dealing with some other chemical, then you may well have obligations under REACH. Now, this next point that I'm going to make is possibly one of the most important points that I can make today, because I think this is potentially going to impact on many businesses. Under EU REACH, import meant importing from outside the European Union into the European Union, but it didn't apply where you were importing within the European Union. So if you were a site based in Great Britain and you were importing, say, from a sister site in France or Germany or Italy, that wasn't or isn't import under EU REACH. So you wouldn't have had an obligation. But under UK REACH, you do now have an obligation. Even though the facts haven't changed, you would now become an importer. So you need to ask yourself, are you, for example, importing from a sister site or from a supplier anywhere within the EU? Now, conversely, if you're buying from a UK-based supplier, from your perspective, it doesn't matter where your supplier is getting the chemical. Your supplier may well be an importer and they would have obligations under REACH, but you as a customer don't. So if you are a GB manufacturer or importer under REACH, you have to register now chemicals with the HSE if you're making or importing more than 1 tonne per annum per chemical. If you already registered that chemical under EU REACH, then you can transfer the registration from the European Chemicals Agency to the HSE under a process that the HSE refer to as grandfathering. And there's no fee for doing that. If, on the other hand, you're importing from an EU supplier and it's your supplier that has registered the chemical under EU REACH, you can continue to import it, but you will have to register it under UK REACH. And there are various deadlines for doing that. So basically, you would have to supply certain information to the HSE by the 27th of October this year, and you would then have a period of either 2, 4, or 6 years to complete the registration, and that period of time is based on the quantity that you're importing and its hazard classification. And note that there are significant fees for registration. They often run at least into the thousands, if not the tens of thousands of pounds, and that's fees that you pay to the HSE. Now, there are special rules for chemicals coming from Northern Ireland. So if you're importing chemicals from Northern Ireland into Great Britain, they are classed as qualifying Northern Ireland goods, and they are not registrable, although the importer or supplier will have to provide the HSE with some information about them. So qualifying Northern Ireland goods are goods which have been in some way manufactured or actually physically chemically processed in Northern Ireland. Conversely, if they are non-qualifying Northern Ireland goods, then they are registrable under UK REACH. So non-qualifying Northern Ireland goods would be goods that have not been made in Northern Ireland at all. So if, for example, they were made in the Republic of Ireland, driven over the border into Northern Ireland and then sold onwards into the UK, sorry, into Great Britain, then they would be registrable under UK REACH. If the goods are going the other way, so they're going from Great Britain to Northern Ireland, then they are registrable under EU REACH. And note, there is no provision for goods going that way to be differentiated, as between qualifying and non-qualifying goods. Now, REACH also requires manufacturers and importers to notify certain articles. So under EU REACH, they're notified to the European Chemicals Agency. That is particular articles which contain substances on the candidate list, where the substance forms more than 0.1% of the article, and where the manufacturer or importer is handling more than a ton per annum of the substance, so not of the article, but of the substance itself. Now, if you're a GB producer or importer, you would now be notifying those articles to the HSE. Note that even if you've previously notified them to the European Chemicals Agency, you still need to have notified them to the HSE. And in fact, the deadline for that has already passed. I'm not sure, I assume that the HSE would still allow you to notify them late, but there was at least theoretically a deadline of the 1st of March this year. Okay, so next, REACH also requires users of certain high-risk materials to obtain authorization to use them. So this is materials on something called the authorization list, and this applies only to about 50 or 60 listed carcinogens and mutagens, etc. So we're not talking here about ordinary hazardous chemicals such as acids and flammables and irritants and so on. Now, the way this works is the applicant would apply for authorization, which they would get from the European Chemicals Agency. And usually that authorization will cover not only the applicant, who's usually the manufacturer, but also their downstream users, in other words, their customers. Now, under UK REACH, the transitional arrangements are, if you're based in Great Britain and you have an authorization under EU REACH, you can transfer your authorization to UK REACH. And also, if you're based in Great Britain and you're a downstream user and your supplier has an EU authorization under EU REACH, you can also still continue to use the substance under UK REACH. In both the above cases, you need to file certain information with the HSE. So next, moving on to the CLP regulation. So this is the Classification, Labelling and Packaging of Substances regulation, which applies basically to suppliers of chemicals. And note in this case, the HSE calls this one GB CLP. Under EU CLP, manufacturers and importers have an obligation to notify certain hazardous substances which they place on the market. That notification goes to the European Chemicals Agency and it's recorded on the Classification and Labelling Inventory. Just for information, those substances are any hazardous substance or any substance which would be registrable under REACH but hasn't been registered, or any hazardous substance which, if it's put into a mixture, it makes the mixture become hazardous. Now, under GB CLP, organisations will have the same obligation to notify substances, but the notification goes on to what becomes the GB notification database rather than the EU Classification and Labelling Inventory. Now, if you've already notified the substance to the EU Classification and Labelling Inventory, or alternatively, if you've already registered the substance under EU REACH, you don't need to re-notify to the GB notification database. Okay, next, the biocidal products regulation. So a couple of changes here. So active substances. The list of EU approved active substances is copied across to the HSE, which will hold a very similar list of active substances. But note that if you are an approval holder, and in order for that approval to continue to be recognised in Great Britain, the approval holder must be established in Great Britain by the 1st of January 2023 and provide certain information to the HSE about that active substance. So if you're not based in Great Britain after that date, that approval would no longer be recognised in Great Britain. What we then get For authorised products, so this is authorised biocidal products, is a very similar arrangement. So EU authorisations will continue to be recognised in Great Britain, but in this case, the authorisation holder must be based in Great Britain by the 1st of January 2022. So the previous one was 23, but for authorised products, you must be based in Great Britain by the 1st of January 2022, failing which that authorisation will no longer be valid. Now, if on the other hand, you're based in Northern Ireland and you have an authorised product under EU biocidal products, then that will continue to be accepted in Great Britain, provided that it is a qualifying Northern Ireland good, so same definition as before, and that you notify the HSE at least 90 days before placing that product on the GB market. Okay, so next I'm moving on to CE marked goods. Now, there's been an awful lot of change here as well. I'm not going to spend nearly so long on this simply because we don't have the time and we don't tend to get so many questions about this. But if you think this is going to apply to you, I would urge you to have a look at the relevant regulations within LUS and of course get in contact with us and ask us any questions if you want to. So the rules here are going to apply to conformity assessment and conformity marking, that is CE marking of goods. So they're going to be relevant to manufacturers, importers and distributors. So if you're placing CE marked goods on the market, this is going to apply to you. So here's the change. So from the 1st of January 2022, you will no longer be able to place CE marked goods on the market. So from that date onwards, you can only place UKCA marked goods on the market. Now, if you've already had goods, so for example, they're on, I don't know, if you're a retailer and you've got them on your shelves, or you've already bought them and they're sitting in a warehouse, that doesn't mean you have to remove them all. Those goods can continue to circulate on the market. So this requirement applies to when they are first placed on the market. Now, in Northern Ireland, they will continue to use the CE mark. So goods cannot be UKCA marked, despite the fact that it's got UK there. Again, this is a little bit like REACH. So UKCA marking will not be applicable in Northern Ireland. So they will continue to CE mark. In addition, they will also, in some scenarios, apply a UKNI mark. Now, this is not the equivalent of the UKCA mark. So the UKNI mark is applied where the conformity assessment is done by a UK-based notified body. And it's applied in addition to, rather than instead of, the CE mark. Now, I mentioned that you get different rules depending on whether the goods are going from Great Britain to Northern Ireland or vice versa. So what we have here is that, as I said before, UKCA marked goods cannot be placed on the market in Northern Ireland, but goods which have been CE and UKNI marked in Northern Ireland can be placed on the market in Great Britain, even beyond the 1st of January next year. Okay, so we then get transportable pressure equipment, gas cylinders. So these rules are a little bit simpler. So we have the carriage of dangerous goods and use of transportable pressure equipment regulations. Now those regulations are primarily about carriage of dangerous goods on road and rail. Fortunately, there are no changes as a result of Brexit to those rules. What those regulations also do is they cover the conformity marking of gas cylinders. So gas cylinders are generally pi marked, so Greek letter pi. But what the Brexit change does is it introduces a new GB specific row mark. So row is a Greek letter, looks like a P in the brackets there. And that is now introduced as an optional alternative to pi marking. So that now means that manufacturers and importers and distributors have a choice. You can choose to use the pi mark or the row mark or both. If you're in Northern Ireland, you only continue to use the pi mark. And if you're simply a user of gas cylinders, you don't need to worry about this. Okay, so that's all of the Brexit related changes to health and safety law. So I'm now going to move on to other non-Brexit related changes to health and safety. So firstly, we have some new work exposure limits. So these are published in the HSE's guidance document EH40, which was updated in January of last year. So there are new or modified work exposure limits for all of those chemicals. I'm not going to go through them. And note that they have also now notified that ethylene oxide is also hazardous by absorption through the skin. So the Mines Regulations 2014 have an updated work exposure limit for respirable crystalline silica, which I put on that slide. So we then also have new health, safety and nuclear fees regulations. Now, a lot of people look at these regulations and assume they don't apply to them because they see the word nuclear. That's not how it works. So these regulations are about the standard fees that the HSE can charge for carrying out their regulatory functions. So if you're a site that the HSE regulates as opposed to the local authority regulating, then these regulations are relevant to you. And what they do is they update the fees. So the most significant implication for these regulations is the fee for intervention scheme. So this is the scheme where if the HSE come to your site and they find what they define as a material breach, then they can raise what they euphemistically describe as a fee. Most people would describe as a fine. So that's where the fee for intervention scheme comes from. It comes from these regulations. These 2021 regulations revoke the previous 2016 regulations and update them. So we then have the electrical and safety standards in the private rented sector, England regulations. So these apply in England only. They apply to landlords of private residential premises, not commercial premises. So they require landlords to arrange a fixed wiring electrical inspection, which needs to have already been done by the 1st of April this year. Thereafter, they have to do regular inspections at least every 5 years. So they have to provide a copy of the inspection to the tenant, and that includes to prospective tenants. And they have to provide a copy to the local authority if the local authority asks for it. Note that the local authority can serve a remedial action notice on the landlord if they think the landlord isn't doing necessary remedial work. So next we have the Smoke-Free Premises and Vehicles Wales Regulations 2020. So these obviously only apply in Wales. Now what these do is they consolidate various previous smoking law, but they introduce one new change. So whereas most UK-based smoking law only prohibits smoking inside buildings, so not outside buildings, what these regulations do is they say that the occupier of a hospital or a school or a playground must take reasonable steps to stop anyone from smoking anywhere on those premises, including outside. So next, we come back to the chemicals regulations. So these are obviously non-Brexit related changes. So firstly, with REACH, there are some new substances added to the authorization list, which I talked about before. And on the CLP regulation, so Annex 6 of the CLP regulation lists over 4,000 chemicals, and it provides the classification, the hazard classification. So it tells you, for example, is it flammable, is it toxic, is it corrosive, and so on. And there are regular updates to that annex, as you can imagine. And then with the biocides regulation, there are also some new approved active substances and new authorized products added to the relevant lists there. Now note that all of those changes, because they came out last year, they apply to both the EU and the GB versions. If you want to see specifically what they are, I'm obviously not going to read them out because it's just lists of chemical names. If you want to see what they are, go into either the EU or the GB retained version, go into the update section, and you can see the amending regulations in there and what they've added. So another change to REACH. So the original REACH regulation required that if you had registered a substance, you had to update that registration if there were any significant changes. But what it didn't do was it didn't provide a deadline for how soon you had to do that. So what we now have is a new regulation, 2020-1435, and that provides deadlines for updating registrations following changes, such as the identity of the registration holder changes, the quantity that you're making or importing changes, if the hazard classification changes, or if you have new changed scientific or safety related information in relation to that chemical. And there are some other circumstances as well. So that regulation provides a period of time within which you've got to update your registration. And note again, that applies to both the EU and the UK versions. So another change, which also applies to both versions, so this is in relation to safety data sheets. So there is a slight change to the layout and information that goes into safety data sheets, and it's principally to include information about whether the substance has or is an endocrine disruptor. And that will come into force on the 31st of December 2022. So we then have a change to the CLP regulation. Again, this applies to both the EU and the UK versions. So if you're supplying a product that contains titanium dioxide, there are new labelling requirements in relation to those products. And they will be applicable from the 9th of September this year. And then we have a change that only applies to the EU version of CLP. Now, this is to provide a unique formula identifier to the National Poison Centre. So what this is where you're supplying a chemical, you have to create a unique code that applies to that chemical and provide toxicological information to your relevant National Poison Centre. The idea here is if you've been poisoned, somebody can contact the National Poison Centre, provide the unique formula identifier, and they can then supply relevant first aid information. Now, this requirement was causing problems for manufacturers who were making a wide range of very similar but not identical products, because it meant that they had to generate a unique formula identifier for every single version of that chemical and provide toxicological information. So those requirements have been simplified for things like certain concrete and cement products, fuels, bespoke paints, and certain other mixtures containing toxicologically similar materials. Now, the reason this simplification doesn't apply in Great Britain is because the HSE has confirmed that within Great Britain, you don't have to generate a unique formula identifier at all, and that you are only encouraged to provide toxicological information to the National Poison Information Service within Great Britain. So that's all of the changes to health and safety law. So the only thing that I have left is new health and safety law on the horizon. This is in relation to fire safety, obviously following Grenfell. So what we have is the Building Safety Bill and the Fire Safety Bill, and we expect there will be revisions to the Regulatory Reform Fire Safety Order 2005. So they are currently in Parliament. There's no point me discussing in any detail what the changes are, because of course they could change again. They're expecting them to significantly revise residential building and fire safety requirements, in particular for buildings over 18 metres high. And they will create a new building safety regulator who will operate from out of the Office for Product Safety and Standards. And obviously, once we have more details, we will provide that in our regular newsletter. And I'm now going to hand over to my colleague Esther, who will cover the environmental changes.
Okay, thank you for your patience there, just while we swapped over. So I'm going to be talking you through the environment-specific updates today. So firstly, we'll have a look at the Brexit changes, and that's following on from Jonathan's information earlier on. And then we'll go through some environmental legislation updates from the last year, closing out with some information on coronavirus. So the first Brexit change that I want to talk you through today is around wooden packaging. So this is a change that we've seen affect lots of organisations in the last couple of months, and this is specifically around when ISPM 15 standards need to be met for wooden packaging used for movement of goods. So ISPM 15 standards, it's an international standard, and it shows that wooden packaging has been treated to prevent the movement of pests with that packaging from one area to another. So it's evidenced using this logo that you can see on the screen here. And you'll often see that branded on packaging when it meets the standard. And the common method of meeting the standard is through heat treatment. So you may have heard the term heat treated pallets before. That is often a way of producing packaging to meet the standard. So we need to use packaging that meets ISPM 15 now for any imports of goods into Great Britain on wooden packaging, as well as any exports of goods from Great Britain from Northern Ireland, the Republic of Ireland, and any other EU country, as well as most non-EU countries as well. And the change here is around Northern Ireland and EU countries. So prior to transition, you didn't need to meet the standards if you were moving goods to and from Great Britain from Northern Ireland and the EU, and now you do. So that's the key change to be aware of here. To clarify though, if you are moving goods on wooden packaging between Northern Ireland, the Republic of Ireland and the EU, they do not need to meet the standards, and that continues to be the same as prior to transition. So timber and timber products more generally then. So the UK timber products regulations now apply to those that are importing, buying or selling timber and timber products in Great Britain. So note again here that we've got a UK timber regulation in guidance, but it's only relevant in Great Britain, so in England, Scotland and Wales. And when we're referring to timber products, the type of thing I mean is like plywood, paper, wooden furniture, and they're listed in the annex to both the UK and the EU versions of the regulations, and the scope of what's covered hasn't changed. So the key change we do need to be aware of is whether you're now considered an operator or a trader under the regulations. So an operator is going to be someone that places timber or timber related products on the GB market for the first time, whereas a trader is based in Great Britain, but buys and sells products that have already been placed on the market by an operator. So you may be in a situation where until January this year, you were considered a trader because you were, for example, in England and you were purchasing a timber product from a company in France or selling to a company in Spain, for example. If you continue to do that now, because that's classed as an import and export into Great Britain, you would now be considered an operator under the regulations and would have extra due diligence requirements to meet. Again, just some clarification that the scope hasn't changed. If you're in Northern Ireland because of the protocol, and of course in the Republic of Ireland, the EU timber regulations apply to you. So looking at changes around emissions trading schemes then. So we've now replaced the EU emissions trading scheme with the UK emissions trading scheme. And that's been established by the Greenhouse Gas Emissions Trading Scheme Order 2020. And that's for UK participants from the 1st of January this year. Principles remain very similar to those of EU ETS as UK ETS. So the regulated activities remain the same. And the opt-out schemes and exemptions still remain available. Something to be aware of if you're in Northern Ireland is that if you were part of EU ETS as an energy generator, because of the implementation of the Northern Ireland Protocol in relation to energy generation, you continue to be part of EU ETS rather than transitioning over to the UK version. However, if you're in Northern Ireland and participate in EU ETS as a different type of regulated activity, you will transfer across to UK ETS along with all others in the UK. Phase 1 of UK ETS is going to run from now until 2030, and we've got these 2 allocation periods you can see on the screen here. And the regulators are coming to the end now of the process of providing new permits. So you should have received the bulk of your permit by the end of December last year, with the supplementary information provided by the end of March. And something to note really of interest is that the annual cap at a UK level has increased by 5%. And the reason we've done that is that the government has got quite ambitious climate change and net zero carbon targets in place for itself. So by increasing this cap by 5% and making it more stringent, we're hoping that it helps to achieve those targets. So moving on to refrigerant gases then. There aren't major changes to tell you about unless you are producing, importing, exporting or destroying F-gases or ozone depleting substances. And if you are in that situation, you've now got a GB quota in place, both for F-gases and ozone depleting substances, and GB reporting mechanisms as well. You need to use those new reporting mechanisms for any activity in 2021, and it needs to be reported by the end of March next year. Something you may be of interest though with F-gases and ozone depleting substances is around qualifications. So in the UK, if you carry out activities in this circumstance, particularly with F-gases, that require qualifications to be in place. So this is things like leak checking of equipment, installation of equipment, maintenance, for example, and your qualification was issued in a EU country, that continues to be recognised for work in the UK. The same can't be said from an EU level though. So if you have UK qualifications for F-gases or ozone depleting substances, they are no longer recognised for work in the EU, unless you're in Republic of Ireland in the transitional period. So UK qualifications, both again for F-gases and ozone depleting substances, will continue to be recognised until the 30th of June this year, and you have the opportunity until the end of this month to apply for an automatic transfer of your certificate to a Republic of Ireland certificate. And if you are successful, that would not only be valid for work in Republic of Ireland, but would also be valid in all other EU countries as well. So I wanted to tell you about some changes in energy-related products. So these are both Brexit and non-Brexit changes to draw your attention to. So we'll start with the non-Brexit changes. And because they're not directly because of Brexit, they affect energy-related products in both the UK and the EU. And this is around the rescaling of energy labels. And this only applies for certain products at the moment. So if you're a supplier or a dealer of the following products, so we've got electronic displays, washers and washer dryers, refrigerating appliances or household dishwashers, then you will have an obligation to rescale the energy label. So what that means is the energy label you can see on screen here, the rating system used to show the energy efficiency of the product has been brought back down from what used to be an A triple star to a G rating, back down to just an A to a G rating. So that's the rating system displayed on that label. And the intention is to make it easier for consumers to understand how efficient that product is. So in terms of when the deadlines are for this applying to you, so if you're a supplier, you've been required to provide a printed copy of this energy label since November 2020, so last year. If you're a dealer of these products, you've been required to provide this new printed energy label at the point of sale until from March this year. So that's a fairly recent change for you. The Brexit changes to talk you through then. So we've got a UK energy label in Great Britain now, rather than an EU energy label. Again, note the difference that it's called a UK energy label, but it's only for England, Scotland and Wales. The difference is that firstly, it's got the Union Jack on rather than the EU flag, and it's also got a QR code on it, and that allows the consumer to scan that to get detailed energy related information for that product. If you're in the EU, if you're in Northern Ireland, you continue to use the EU energy label, and that has the EU flag and doesn't have the QR code on there. We've also got some changes around CE marking with energy related products as well. So prior to Brexit, you were required to CE mark any energy related products both in the UK and the EU. Now, if you want to place those products on the market in Great Britain from the 1st of January 2022, you will be required to UKCA mark them instead. And the changes that Jonathan went through in relation to CE marking here in terms of Northern Ireland and any transitional arrangements also apply. And I'd again urge you to go and have a look at the entry on loss and the guidance if you think this might be applicable to you. Final change to discuss on this topic is that if you're in Great Britain and you're a supplier or dealer, you now no longer have to maintain the product database. So that's been removed in Great Britain. It's because we don't have a GB or a UK equivalent to replace this EU product database, and it's instead been replaced with the QR code requirement. So moving on to plant protection products then. So really just to clarify for you here that all existing active substance approvals, plant protection product authorisations and maximum residue levels continue to be valid in Great Britain as they did in the UK prior to transition under EU regulations. There is a transitional measure to make you aware of in the active substance approvals if they were due to expire before December 2023. Have been extended for 3 years, so you can that's to give the HSE some time to decide whether they want to approve them or not. And any new applications or applications for renewal are going to continue to be made to the HSE in the same format. Again, just to clarify, if you're in Northern Ireland because of the protocol, or of course in the Republic of Ireland, the EU plant protection products legislation continues to apply. For fertilisers, Prior to Brexit, if you were selling fertilisers in the UK, they needed to be marketed as EC fertilisers, along with the rest of the EU. Now, if you're wishing to sell fertilisers in Great Britain, they need to be sold as UK fertilisers instead. And to be able to do that, you need to be established in the UK, and the products need to be tested by a UK approved lab. There is again a transitional measure in place here. You can see a theme. And this one says that if you want to continue to sell or manufacture EC labelled fertilisers in Great Britain, you can do so until the 1st of January 2023, as long as they conform to EU standards. If you want to sell fertiliser products manufactured in Northern Ireland in Great Britain, you can do so as long as they are considered qualifying Northern Ireland goods. If you want to manufacture and sell your products in Northern Ireland or the EU, they continue to be required to be labelled as EC fertilisers, meet the EU standards, and you need to be established in the EU or Northern Ireland. If you want to sell UK fertilisers in Northern Ireland, you can do so, and that's through the domestic fertiliser regime. And the reason that's been put in place is to prevent there being a block on the sale of any fertiliser products made in Great Britain in Northern Ireland. So we've got two different types of fertiliser regulations running alongside each other there, the EU version and the domestic fertiliser regime in Northern Ireland. So looking at animal byproducts then. So this is an area where there's lots of complex documentation changes, particularly around imports. So I'm not going to be able to go into them in great detail now, it's just to give you some headline points really. So there are changes for imports of some animal byproducts into Great Britain. Again, can't go into detail on what they are now. I'd urge you to go and have a look at the entry on this and the guidance if you think this might be relevant to you. The first date that's in place for this is from the 1st of October 2021. You're going to need a health certificate for that import and it needs to be pre-notified. From the 1st of January 2022, it's going to need to enter Great Britain through an established point of entry. There's no change to movements of animal byproducts between Northern Ireland and the EU, again, because of the protocol. And if you're wanting to move goods from Northern Ireland to Great Britain, you can do so freely as long as they are considered qualifying Northern Ireland goods. A change to the scope of animal byproducts to just be aware of is around catering waste. So international catering waste is now considered any catering waste from transport vehicles travelling outside of the UK, Channel Islands and Isle of Man. And that is still considered the Cat 1 waste, so the highest risk level of animal byproducts. Domestic catering waste now only includes catering waste from transport vehicles travelling within the UK. And again, that continues to be considered category 3, which is a lower risk animal byproduct. The change here is that prior to transition, if you were producing catering waste on transport vehicles travelling between the UK and the EU, it would have only been considered domestic catering waste, whereas now it's considered international catering waste and is considered a higher risk animal byproduct with additional duties to be aware of. And looking at plant health, again, lots of complex documentation changes here. So I'd urge you to go and have a look at the entry if you need more detailed information. But the headline here is that we've now got UK plant passports, which have replaced EU plant passports for operators in Great Britain. If you have an EU plant passport that was issued before the 14th of December 2019, that will continue to be valid until the 14th of December 2023. And if you were authorised to issue plant passports under EU law prior to transition, that authorisation is transferred and you can now issue UK plant passports. If you want to move plants in Northern Ireland that require plant passports, you will now continue to use EU plant passports, both for movements within Northern Ireland and from Northern Ireland to the EU. And there are much more strict rules in place for moving plants from Great Britain to Northern Ireland in place now, and that's because Great Britain is considered a third country. So in some specific circumstances, that movement might actually now be banned, But in most circumstances, it will be that you now require additional documentation called a phytosanitary certificate. So moving on to the non-Brexit environmental updates then. So what else has been happening in environmental law in the last sort of 12 months? First area I want to draw your attention to is quite a big amendment regulation called the Waste Circular Economy Amendment Regs. So these made changes to implement the circular economy package in the UK, with the majority of the changes occurring in England and Wales, and the duty changes mainly being for local authorities and waste operations. So that's by waste operations, I mean people that are moving waste, managing waste on other people's behalf, not just doing the kind of standard thing of having waste on their site, segregating it and having it removed by a third party. It's mainly treatment activities. So the changes for you are around separate collections of waste. So they specify, and this is particularly relevant for local authorities, when separate collections are not needed. They also clarify that unlawfully mixed hazardous waste has to be segregated unless it is technically infeasible to do so, as well as prohibiting the mixing of waste oils where the mixing of those oils would prevent the regeneration or recycling of them, and the regeneration or recycling was the most environmentally beneficial option. There are further restrictions in place around waste incineration and landfill. So it states that if you are collecting waste with the intention of recycling or reusing that waste, it can't then be redirected for incineration and landfill. And there are some additional duties for waste exemptions, particularly hazardous waste exemptions. So these are around reporting and recording duties. If you have a hazardous waste exemption registered, it might be something worth taking a look at if you're not already aware. Moving on to packaging producer regulations then. So the packaging producer regulations have been amended in all jurisdictions of the UK, and this is specifically around packaging producer targets. So following consultation, the government has made a decision to remove the packaging recovery target. So packaging waste recovery essentially means incineration of packaging waste, and by removing this, we only have a recycling target available now. What that means for you in terms of your duties doesn't actually affect you very much in terms of change if you meet your obligations as a packaging producer through being part of a compliance scheme, as the operator will manage that on your behalf. If you are meeting your obligations as a packaging producer independently of a compliance scheme though, you do need to be more aware of this change, as your targets will be based on the information you input into the National Packaging Waste Database, and that's automatically generated by that. So it's really important you get that information right that you input. Moving on to two new entries and new regulations we've seen that are a direct result of the Single-Use Plastics Directive. So this first one only applies in England at the moment. However, it might be of interest to you if you're carrying out similar activities in other jurisdictions of the UK. And the reason for that is because we know it's been under consultation, so it's likely that similar regulations will be published in maybe the not so distant future. So this is a ban on the supply of single-use plastic straws, cotton buds, and drink stirrers. There is a key difference that straws and cotton buds can still be sold to businesses but not end users, whereas plastic stirrers can't be sold to either businesses or end users. It's more absolute. There are exemptions available to you to make you aware of if they may be of interest. And the one I really want to draw your attention to here is around catering establishments and retail pharmacy, and that's for plastic straws. So you can continue to supply them in those types of establishments, but you have to meet the conditions that you don't have them on display and you don't offer them up to the public. They have to be requested. So if you want to use one of these exemptions, please go and have a look at the detailed conditions that must be met. And then moving on to a new deposit and return scheme in Scotland. Again, we may see similar schemes in other jurisdictions of the UK. So just because you're in Scotland doesn't mean it's not entirely relevant to you. So this scheme is going to start from July 2022, and it's going to require producers and retailers of drinks used in single-use packaging, not just plastic, but also metals and glass, so like cans and bottles too. And the requirements on producers are going to be that they register, they accept the return of packaging that they've sold, they pay consumers the full deposit, and that they meet minimum collection targets. If you're a retailer, your main duty is going to be to operate return points so that the packaging can be returned. Moving on to an extension to the climate change agreement scheme then. So we've seen an extension of this scheme until the 31st of March 2025. It was due to end in 2023 initially, so that's a 2-year extension there. And as a result, we've now got a new target period 5 added, which runs from the 1st of January 2021 to the end of December 2022. You will have seen that you've had existing agreements vary to reflect this. The key difference is that there's a new base year for this new target period of 2018, and this is different to the previous base years used. So that might mean that you've got quite different targets this time that might be much easier for you to meet or much more difficult. So if you are part of a climate change agreement or are planning on being part of one, it's definitely worth having a look at this to see whether how your targets may have been affected. Minor amendment to the energy performance of buildings regulations in England and Wales around TM44 assessments, and this is specifically the duties of inspectors. So TM44 assessments are the inspections of the energy efficiency of air conditioning systems. The minor change in duties is just around the information that they have to include. But what I do really want to draw your attention to here is that in the explanatory information provided with the amendments, the government clarified that following consultation, a decision has been made to keep the threshold for when a TM44 assessment is required at 12 kilowatts, so a total rated output of 12 kilowatts. This is moving away from an EU decision to increase this to 70 kilowatts. So if you are expecting that to increase and therefore thought you may not need to do a TM44 assessment next time, this clarification is given to say that that's not the case. The final amendment regulation that I want to talk you through today is in relation to polychlorinated biphenyls, also known as PCBs for short. And you can see the 2 amendment regulations that do this in England, Scotland and Wales here. And the reason for this amendment regulation is that we need to make sure that the UK is implementing the Stockholm Convention in relation, which is an international treaty on persistent organic pollutants, or POPs for short. And PCBs are a type of POP. So what that treaty says we need to do is make sure that any PCB contaminated equipment is decontaminated or disposed of by the 31st of December 2025. But considered PCB contaminated if it contains over 0.005% PCBs by weight, and a total volume of PCBs greater than 0.05 cubic decimeters. So common equipment that may contain this is transformers, power factor capacitors, and heat transfer equipment. Importantly though, if you have equipment on your site that has PCBs in, but it contains it in less than these thresholds, you can continue to hold them until the end of their useful life, but you need to decontaminate or dispose them as soon as possible afterwards. So looking forward into environmental legislation in the next 12 to 18 months then. The Environment Bill is still coming up. It's still going through Parliament and being debated. It's still got a long way to go as well, and that's been delayed quite significantly because of Brexit and COVID. So we don't really have a timescale of when we will have that published. Lots of changes could occur with this, so there's no real reason to go into any detail with that now, just to be assured that it's on our radar and should be on yours too. And as we get any detailed information or the information we feel might be of interest to you on this, we will provide it in the newsletter, of course. And then once it's finally published in legislation update service as a whole. The change we are more certain about though is around plastic packaging tax. So this is a new tax we expect from April next year, and we expect it to come into law as part of the Finance Act 2021. Looks like it's going to tax plastic packaging with a recycled content of less than 30% at about £200 per tonne. And you're going to need to pay that if you are a manufacturer or an importer of that packaging into the UK. Important to note here that it looks like imports going to include filled and unfilled packaging. And there will be an exemption, it looks like, for you if you are manufacturing or importing, or both, less than 10 tonnes of packaging a year. So worth considering what maybe the financial implications might be for your business here if you haven't already. Again, we will provide you with updates on this as often as we can. There was an update in last month's newsletter, so if you didn't get a chance to have a look at that, please go and do so. And finally, moving on to the final topic of the webinar for today, it wouldn't be a legal updates webinar in 2020 if we didn't talk about coronavirus. What we want to do here is just draw your attention to the fact that there are lots of COVID regulations about. So this is particularly from a health and safety perspective. The Health and Safety Register has been inundated with COVID regulations in the last 12 months. Lots of them are time limited and will expire automatically, and that's already happened with quite a lot of them. And what happens on your legal register when that occurs is that we archive them on the system. So when we archive them, they will be removed from your main register because they're no longer relevant to you anymore, but you will still have them to look through. You're not going to lose any compliance information. They're still all available to you for interest. As well, to address the fact that they've been amended lots of times as well. So you'll have seen in your newsletters, again, from a health and safety perspective particularly, that you've got lots and lots of COVID amendments there. That's because they're being changed all the time. And if you've got more than one jurisdiction relevant in your legal register, you will have even more legislation in there. And that's because we've got different regulations in all 4 jurisdictions of the UK, as well as Republic of Ireland as well. We only include any legislation in LUS if it directly applies to employers or workplaces, and therefore you may have some compliance duties for it, or if it affects individuals and may be of interest to you as an organisation. So, for example, in relation to domestic travel, because that may affect your employees' ability to commute to work or carry out certain activities. These next slides here are a list of the current COVID legislations, pieces of regulation, apologies, in all jurisdictions of the UK and the Republic of Ireland, just to allow you to have a bit of an overview of what we've got there at the moment and whether you need them in your register or not. So please don't worry again about scribbling any of this down. The slides will be available to you after. We can't guarantee how long this will be relevant for. It might be that the government changes the legislation again in a couple of days or weeks, but it's here for information for now. So these are the ones that apply directly in workplaces. We've again got the following that apply to individuals and might be of interest. So you might want to mark them as for information only in your register. And this is in England and Wales. We've then got the following also relevant to individuals in Scotland, Northern Ireland and the Republic of Ireland. And then these ones are relevant to businesses, again, for interest because they provide local authorities with powers. Final area to cover today is COVID from an environmental perspective. And the main change here is around COVID regulatory position statements. So we've seen all regulators in the UK issue these. And again, they are time limited and they include specific conditions. And the reason they've published these is to clarify how they will be regulating during the pandemic, because obviously things need to change. Cover the following topics, but the one I want to particularly draw your attention to is the waste management area. So the Environment Agency, for example, have issued a position statement that covers social distancing whilst handing over waste paperwork. It doesn't say that you don't need to hand over waste paperwork. There are very specific conditions that need to be met. You continue to need to meet your obligations and your duty of care requirements. So I'd really urge you to go and have a look at those entries on LUS if you haven't already done so and see whether they're relevant to you, what the conditions are and when they expire. So thank you so much for your time today. I hope you found that informative and somewhat interesting. If you've got any additional questions or if you want any additional support in terms of environment, health, safety or quality management system support, or you want to know any more information about the legislation update service and the features that are available to you on that, then please do get in touch with us and we will do our best to help you.